In this section, we're going to look at partnership voting in a little bit more detail. Let's refresh our memory about what we've already learned. We know that voting in the partnership is equal voting. Partners vote on a per capita basis without regard to the capital contributions they have made to the partnership. There are no formal meeting requirements. Both of those are default rules. We can change them in our partnership agreement. With respect to ordinary matters, we simply require approval of a majority of the partners. With respect to extraordinary matters, however, we require approval of all of the partners. Same thing for amendment to the partnership agreement. All partners must agree to it. And same thing with respect to admission of a new partner. All partners must consent to the admission of a new partner. Now, with respect to all of these, we can change these rules. We can change these default rules in our partnership agreement. Let's talk about partnership voting on ordinary business matters. The law does not have a list of ordinary matters, nor does it have a definition describing what would constitute an ordinary matter. Effectively, if it's not extraordinary for the partnership, it is ordinary. To approve an ordinary matter, we need a majority vote of the partners. We have no formal meeting requirements. We do not have to use a specific type of mechanism. We might want to put formal meeting requirements and specific mechanisms in our partnership agreement, but unless we have those in our partnership agreement, the law does not require them. Here's an interesting aspect of voting on ordinary matters. The partners will not be voting on every ordinary matter. As a matter of practice, we couldn't vote on every ordinary matter. If we voted on every ordinary matter, the business of the partnership would grind to a halt. So we will only really be voting on matters, ordinary matters, where there is a disagreement among the partners. We also need a vote for an ordinary matter that would change the status quo, right? So imagine we're deciding between two courses of action. One course of action is something we've already been doing. The other is an alternative. When we vote to change the status quo, which is what we've been doing, we need to approve the alternative. So here's an example. Imagine in our partnership, our partners often travel to New York City for partnership business, and when they do, it has been customary to stay in a particularly fancy and particularly expensive New York City hotel. Some of the partners want to stop this practice, and so they bring it to a partnership vote. The partners vote on the matter, but they are deadlocked 4-4. So we have two courses of action. One, the current practice, which is being allowed to stay in this particularly expensive New York City hotel, and we have the alternative, which is to stop that practice. So we have the status quo, being allowed to stay in the hotel, and then we have the alternative, which is to stop the practice. We have a deadlock 4-4. So the question becomes now, what is the situation in the partnership? May the partners still continue to stay in this particularly expensive New York City hotel? And the answer is yes. Why? Because we did not get a majority vote of the partners to change the status quo. We had a 4-4 deadlock, and therefore a majority did not vote to change the status quo. Let's talk about partnership voting on extraordinary matters. Remember, the default is that we require unanimous consent of all the partners to approve an extraordinary matter. There are no specific voting formalities or voting mechanisms that we must use unless our partnership requires otherwise. The typical matters which are considered extraordinary are admission of a new partner. This is very important to the partnership. If we want to admit a new partner, we need consent of all the partners. This should make sense to you. Remember, the partners bear personal liability for the debts of the partnership, and therefore it is important to trust the people that are your partners. Your partners can bind the partnership. Therefore, you want to be able to trust them. Secondly, you want your partners to be financially viable. Remember, partners bear joint and several liability for the debts of the partnership, which means if the partnership cannot pay off its debts, the creditors can go after one partner. And that partner naturally would be able to sue the other partners for contribution, but that one partner can be liable for the entire kit and caboodle. If I am that partner and I get sued and I am liable for the partnership's debts, I want to be able to sue the other partners and get contribution. If my other partners are judgment proof, if they do not have any assets, if they're not financially viable, then I'm going to be left holding the responsibility to pay off the partnership debts. So admission of new partners is very important to the partnership. Amendment of the partnership agreement also requires consent of all the partners. And finally, naturally, acts in contravention of the partnership agreement require approval of all the partners. The Revised Uniform Partnership Act does not have a list of what type of transactions constitute extraordinary transactions for a partnership. We can look at what we've learned in the corporate context to kind of give us an idea. So remember, in the corporate context, we said shareholders will not normally vote on transactions unless they are fundamental transactions. So in the partnership, we're talking about extraordinary transactions. In the corporation, we're talking about fundamental transactions. What type of things constitute fundamental transactions in the context of the corporation? We said MADs. Mergers, amendment of the Articles of Incorporation, dissolution, and sale of substantially all of the corporation's assets. Any of these types of transactions in the partnership context will also be considered extraordinary transactions. But there may be certain types of transactions that we would consider extraordinary in the partnership context that we would not consider fundamental in the corporate context. Let's look at an example. Remember, we gave this example that we have a corporation and the board of directors decides to borrow a large sum of money at a high interest rate to engage in a very risky business venture. Would we need approval of the shareholders? And the answer is no, because it's not one of the MADs. It's not a merger, it's not amendment of the Articles of Incorporation, it's not dissolution, and it's not a sale of substantially all of the assets. And therefore, the board of directors could make this decision without the approval of the shareholders. Well, imagine we want to do the same thing in the partnership. The partners would bear personal liability for the debts of the partnership, and therefore when the partnership engages in borrowing from a bank at a high interest rate to engage in a particularly risky transaction, this would probably be considered an extraordinary action in the partnership context. In the Uniform Partnership Act of 1914, the old Uniform Act, there was indeed a list of transactions that would be considered extraordinary in the partnership context. There's a list. You can read the list. Some of those things wouldn't apply anymore. Some of them still would under the Revised Uniform Partnership Act. The two most important things is disposal of the goodwill of the business. The goodwill of the business is just the value of the business over and above its assets minus liabilities. It's effectively the value of the business. So we talked about how to value a business, and we understand that a business is worth more than its assets minus liabilities. The value of the business is in the ability to generate profit. So anytime you're selling the business or you're selling the goodwill of the business, the ability of the business to generate these profits, it is an extraordinary matter. Any act that would make it impossible to carry on the ordinary business of the partnership, any act that would effectively draw the partnership to a close, would make us unable to carry on our business, this is an extraordinary matter and would naturally require the vote, the unanimous consent of all the partners, unless the partnership agreement said otherwise. Let's talk about access to partnership books and records. Remember, we talk about shareholder access to books and records. Go back and review your notes on that. But sometimes, let's say often, a shareholder is going to have to show that it has a proper purpose for accessing corporate books and records. It's different in the partnership. In the partnership, we're assuming that the partner is going to be involved in the business of the partnership. And because the partner is going to be involved in the business of the partner needs to have an almost unfettered right to access partnership books and records, where it's different in the corporate context. In the corporate context, we're not assuming that the shareholders are going to be operating the business. Matter of fact, we're assuming otherwise. And therefore, having shareholders always having an unfettered right to access corporate books and records just gets in the way of the operation of the business. The corporate board of directors will be running the corporation. But in the partnership, the partners will be involved in direct management of the business of the partnership, and therefore they need an unfettered right to books and records. So a partner has a right to inspect partnership books and records subject to ordinary business hours and reasonable fees for copies, etc. Now, that's when the partner demands access to books and records. But even when a partner does not affirmatively demand or request certain books or records, a partnership must provide a partner without the partner's request with any information concerning the partnership's business and affairs reasonably required for the proper exercise of the partner's rights and duties. So if I'm a partner in a partnership, the partnership is going to have to provide me with certain information that's going to allow me to exercise my rights and duties in a reasonable manner. With respect to other partners, I, as a partner, am entitled to information from my partners. So I can demand information from my partners, and my partners can only refuse it if my demand was unreasonable. Now, without demand, the partners must give me information concerning the partnership's business and affairs reasonably required for my proper exercise of my rights and duties. So, to summarize, if I request information from the partnership, it must give me that information. If I request information from my partners, the partners can only refuse me if my request is unreasonable. If I am exercising my rights and duties as a partner, the partnership and my other partners have an affirmative duty to give me the information that I need to properly exercise my rights and duties, even if I don't ask for it. And naturally, when I would have the same obligation to my co-partners. Let's talk about partnership authority. We already know that it's basically the same as the authority we've already studied for any other type of agent. There's express authority, implied authority, and apparent authority. The one kicker in the partnership context is that I, as a partner, would have apparent authority to bind the partnership simply by virtue of my status as partner. My status as partner gives me apparent authority to bind the partnership. Let's talk about that in a little bit more detail. Let's talk about apparent authority based on partnership status. And we'll look at the wording of the two different acts. A partner has authority to bind the partnership for apparently carrying on in the usual way of the partnership business, the business of the partnership. That's UPA, Uniform Partnership Act of 1914. The Revised Uniform Partnership of 1997 phrases a little bit differently. A partner has the authority to bind the partnership for apparently carrying on in the ordinary course of the partnership business or business of the kind carried on by the partnership. So if it's an ordinary partnership matter, I have the authority to bind the partnership simply because I am a partner. If the third party, however, knows or has reason to know, right, has received some sort of notification that the partner does not have actual authority, then she is not reasonable in believing that the partner had authority. So a partner will have the apparent authority to bind the partnership for ordinary business matters unless the other party knows the partner has no authority or has received notification that the partner has no authority. Finally, let's talk about the authority of other employees of the partnership. Naturally, a partnership is a business. The partners are working for the partnership, but the partnership might have other employees. What is the authority of those employees to bind the partnership? Naturally, this is just the general principles of agency that we've already discussed. Express authority, implied authority, and apparent authority. Just quickly, let's review it. Did the partnership express authority, right? We're asking whether the employee had express authority, and what we need to know is, did the partnership expressly vote to give the employee the authority to enter into the transaction on behalf of the partnership? Implied authority. Did the employee reasonably believe that she had the authority to bind the partnership in this transaction? And finally, apparent authority. Did the third party reasonably believe, based on the actions of the partnership, that the employee had the authority to bind the partnership in this transaction?